Hi everyone, welcome back to Automobile Insurance Law. I hope you are all well and healthy and that your families are healthy, and hopefully all of you are able to keep your social distance without too much inconvenience. I know you probably by now have seen the announcement that I posted on Blackboard. Our class most certainly will go on. We will be able to complete the remainder of the semester. I will be posting 3 videos on Blackboard for you to view at your convenience. These 3 videos will represent the 3 remaining lectures, the one from March 17, March 24th, and the one that would have taken place on March 31. This is the first of those 3 lecture videos. If at any point you have any questions or need any assistance, please do not hesitate to email me. I will be available for questions. I will respond to you promptly. If you would like to speak, please email me your telephone number and I will be sure to call you. If there's a time that's best for you, please let me know that as well. The examination is now going to be a take-home exam. I am still ironing out the details and I will have more information on that shortly. Please watch Blackboard for a posting. So without further ado, let's get into the material that we were going to be dealing with on March 17th. So this lecture will focus on tort claims, and what we are going to look at here is the parties that should be included in a tort claim, both as plaintiffs as well as defendants. We will also examine some common defenses that are typically used in these tort claims, such as, for example, the seatbelt defense. Now, I looked at the readings for this particular class, and I noticed that there were some sections of the Insurance Act as well as the Westerhoff decision listed as a reading for this class. Those are actually readings for the March 31 class. You'll see that they are, I believe, duplicated there as well on the syllabus. So, if you did read them, you certainly are ahead of the game here. So let's talk about the parties. There's obvious parties to be included. I mean, certainly the injured plaintiff is an obvious party that would be included, as well as the driver of the at-fault vehicle. But then there's also a number of plaintiffs that are not obvious. So, we look at family members of the injured party who can and cannot be included. We also, will look at, should a municipality be included? Should a tavern that served the driver alcohol be included? And so on and so forth. So let's talk first about the plaintiffs who should be included. You can see my cartoon. Well, Mr. Spanthorpe, we think you've got a very good claim on your car accident insurance for your whiplash injuries. So obviously, the injured plaintiff is the one that needs to be included. Beyond that, and we've talked about this briefly throughout the course, the injured plaintiff's family members have a right, certain family members, not all of them, but certain family members have a right to be included as a Family Law Act claimant. And the types of family members that should be included are listed at Section 61 of the Family Law Act. You can see from this section and what I have highlighted in bold that the family members to be included are the injured party's spouse, children, grandchildren, parents, grandparents, brothers, and sisters. So, children would include both biological children as well as adopted children or somebody who the individual treats as a child of their own. But when you look at that list, it is an exhaustive list. These are the only people that have a right to a Family Law Act claim. So, for example, in-laws would not be included, right? A mother-in-law or a father-in-law could not have a right to a claim. And these claims arise both when the injured party dies as a result of a collision, as well as when the injured party is injured as a result of the collision. And these claims are for the family members' damages for what we call loss of care, guidance, and companionship. So the change in their relationship with the injured party, any nursing services they may be required to provide to the injured party, or that the injured party can no longer provide to them. Any income loss they may suffer because of the injured party's accident, whether it be the loss of the injured party's contribution to the household income in the case of a fatality, or if the family member had to take time off to assist the injured party. Now let's look at the definition of spouse, parent, and child, because obviously in today's day and age, that definition is wide ranging. So with respect to a spouse, the Act defines a spouse as two persons who are either married, or if they are not married to one another, they have cohabitated continuously for a period of not less than 3 years, or they are in a relationship of some permanence if they are the natural or adoptive parents of a child. So you've got marriage, you've got not married but live continuously for a period of not less than 3 years, or in a relationship of permanence if they are the natural or adoptive parents of a child. Now, the date that's important in determining if the individual is a spouse is the date of loss. So if you've lived together for 2 years and 11 months before the date of the accident, they would not be considered spouses for the purpose of that accident. They have to, if they're not married, have lived together continuously for 3 years prior to the collision. With respect to the definition of parent, it certainly raises, questions. Does it include a step parent, as I mentioned earlier, an in-law, a foster, or an adoptive parent? Parent is defined in the Act as a person who has demonstrated a settled intention to treat a child as a child of his or her family, except under a foster arrangement, so an arrangement where the child is placed for valuable consideration in a foster home. So if the individual has demonstrated a settled intention to treat the person as his or her own family, and you are not in a situation where he is being paid to do so, the individual would be classified as a parent. With respect to child, it raises, similar questions. Does it include a stepchild, an adopted child? And similar to the definition of parent, the definition of child includes a person whom a parent has demonstrated a settled intention to treat as a child of his or her family, and again, with the exception of a foster home situation. So now that we know who can advance a Family Law Act claim arising from an accident, we then need to look at what can they actually claim for. And Section 61, subsection 2 itemizes the potential claims that a Family Law Act claimant may have. And these claims include incurred expenses, so things that the family member has paid for. If they paid for treatment for the injured person, if they paid for psychological counseling for themselves, mileage if they had to drive to and from appointments, housekeeping expenses, funeral expenses, anything that the person has had to pay out of pocket that is not recovered through other means. It also includes costs to visit the person while he or she is in the hospital and recovering. So if the family law claimant had to buy, a plane ticket to travel to Toronto to visit the individual while they were in a rehab facility, that would be recoverable provided it wasn't paid through the accident benefit carrier. The same collateral damage deductions apply to Family Law Act claimants as they do to injured plaintiffs. And it's also important to know that those who are eligible for a Family Law Act claim are also eligible for a SABS claim. So if the individual has suffered any sort of disability as a result of the collision, even though they weren't involved in the collision, they may bring a SABS claim. So often you'll see this happen in fatality or severe collisions where the family members will bring a claim and seek psychological counseling paid through the SABS carrier. And that is certainly something that is available to them and would form as a collateral deduction on the tort claim. Other things that family claimants can sue for include services that they provided to the injured person. So if they provided attendant care and were not paid through the SABS carrier, because you'll recall the definition of incurred under the SABS legislation, if the family member is providing the care, often they are not entitled to compensation. They can claim compensation in their tort claim. They can also claim services such as housekeeping, caring for the children, and basically what you do is you try to recover the value of those services that the family member provided. And then they can also claim for their emotional loss, and you can see that in subsection E, where it lists an amount to compensate for the loss of guidance, care, and companionship that the claimant might reasonably have expected to receive from the person if the injury or death had not occurred. This is the emotional loss, similar to a pain and suffering claim for an injured party. It's that emotional loss that they've had to endure because of the individual's death or injury. It includes things such as loss of advice, loss of care that would have been provided to them had the deceased survived, loss of activities that they enjoyed doing together, and really boils down to the emotional elements of their relationship. So these are all potential damages that family members may claim. Now, it is not an exhaustive list. The list of damages include all of these items, but it is not limited to them. A frequent category that a family member will seek to recover is loss of income. So if the family member, for example, had to take time off work to care for the injured person, they will similarly make a loss of income claim. And again, that loss of income claim could also be recouped through a SABS claim. I have a client right now whose mother passed away in a very, very tragic accident involving criminal wrongdoing on the part of the tortfeasor. And my client has taken it very hard and she's been really struggling and she hasn't been able to work for the past 6 months. She was able to make a SABS claim and she's receiving an income replacement benefit through the SABS carrier. Her tort claim then would be the additional income loss that she could not recover through her income replacement benefit. Now, keep in mind, an income claim for a Family Law Act claimant is similar to an income claim for the injured party. It is still limited to 70% of the individual's gross income. There is no recovery for the first 7 days, and it is subject to deductions for collateral benefits. Another common category that we will often see with Family Law Act claims is what we call loss of dependency. So if a person is killed in a motor vehicle accident, the remaining dependents of that individual can bring a loss of dependency claim. And basically what they are seeking is the recovery of the income that the deceased would have contributed to the household because they were, in essence, dependent on the deceased's income. The case law indicates that a claim of up to 70% of the deceased income for the spouse may be made, and 4 to 5% of the deceased income per child may be made. And the reason the spouse's income is limited to 70% is because had the deceased survived, some of his or her income would have been spent on him or herself. And so the case law limits it to 70%. Now, when assessing damages of Family Law Act claimants, it's important to remember, again, that they are subject to the same rules as the injured claim. Their claim is what we call a derivative claim. It is derivative of the injured party's claim, meaning that it flows from it. So if the injured party is contributory negligent, the Family Law Act claimant's damages will be reduced by the same contributory negligence percentage. So whatever happens to the injured party's claim will similarly happen to the Family Law Act claim. So again, if the injured party does not pass the threshold, the Family Law Act claimant is also not entitled to their loss of care, guidance, and companionship. However, Family Law Act claimants are not fully subjected to the deductions for collateral benefits. There is one exception. So think of the situation where the deceased had $100,000 in life insurance. That is, in essence, a collateral benefit. Then the deceased receives $50,000 in Section 61 Family Law Act damages. The deceased is still entitled to receive both. There is no collateral deduction related to the life insurance. It is not deducted from the Family Law Act damages. Section 61 of the Family Law Act specifically stipulates that Family Law Act claims will not be reduced by any benefits paid as a result of a contract of insurance. Similarly, the death benefit received through the SAB. So remember we talked about the $25,000 available to the spouse and the $10,000 available to the dependent. Those death benefits are not deducted from any award of Section 61 Family Law Act damages. The family member will receive both the benefit and his or her tort losses. There is no collateral deduction. So that pretty much sums up who should be included as a plaintiff. So if you are acting for the plaintiffs, you obviously need to put in the injured party, and then you need to explore what potential Family Law Act claimants may exist. And so what I will typically do is have a conversation with the injured party and then speak to each of the potential claimants to see if I feel that they, in fact, have a claim. Now, remember from our class where we dealt with the deductible, Family Law Act claims are hit with a deductible as well. And right now it's at about $19,000 approximately. You can take a look back at the slides from that class. So when you're canvassing Family Law Act claimants, you want to make sure that their claim will likely exceed that deductible. And so I will usually do an assessment of what the losses are for the particular family member and determine whether or not I think there's a possibility of that family member exceeding the deductible. Also remember, though, that if it is a fatality case, there is no deductible, meaning the family members are entitled to 100% of their losses. So let's move on now to the defendants. Who should you include as a defendant in a lawsuit? And I've listed a number of possibilities. The driver is the obvious defendant to include. So, the driver's the one that blew the stop sign or rear-ended the plaintiff's vehicle. So certainly the driver would be included. Number 2 would be the owner of the vehicle the driver is driving. Number 3 would be lessors, so if the owner leased it through Ford Credit, for example. Number 4 would be the individual's own insurer, and we talked about uninsured and underinsured benefits. And then number 5 is unprotected defendants. So defendants that do not have the benefits of the deductible and the threshold. So this is where we would be dealing with municipalities and taverns. So someone other than a person involved in the collision. And so what I'm going to do is go through each of these. So certainly, the driver is, the easiest one to determine. So whoever's operating the vehicle certainly needs to be included. With respect to the owners, you will recall that the owner is vicariously liable for the actions of the driver, so long as the owner consented to the driver's operation of the vehicle. And so for that reason, the owner is similarly a defendant that should be included. So just as a refresher, the Highway Traffic Act indicates in section 192, subsection 1, that the driver of a motor vehicle is liable for loss or damage sustained. And then subsection 2, which I've highlighted in bold, indicates that the owner is liable for loss or damage sustained by any person by reason of negligence in the operation of the motor vehicle. So remember, if you lend out your car to your roommate and your roommate causes an accident, you as the owner of that vehicle is just as liable as your roommate is. And subsection 6 indicates that they are liable jointly and severally. So what typically happens when you're filing a claim is you would sue both the driver and the owner of the vehicle. And typically the owner's insurance company would be the one to respond and would defend both parties. Now, you should remember the term joint and several from your torts class. And basically what it means is that they are jointly and severally liable. So while the owner's insurance company will respond if the claim exceeds the insurance limits that are available and the plaintiff pursues the owner and driver personally, they are both responsible for all of the losses. So if the driver doesn't have assets, but the owner does, the owner is required to pay all of the damages beyond the insurance limits. Now, section 267.5, subsection 10.1 of the Insurance Act does, however, limit the vicarious liability of any other party to the liability for which the protected defendant is liable. In essence, what that means is that anyone who's vicariously liable will have the same benefits of the deductible and the threshold and the collateral deductions. So they will not be on the hook for anything more than that which the protected defendant is liable. Now, lessors. A lessor is vicariously liable for the actions of the driver and the owner, but there are some exceptions. So the lessor does get credit for any amounts paid by the driver or the owner's insurance company. So let's assume a situation where John Smith is operating the car. It is owned by John as well. So he is both the driver and the owner of the vehicle. He leased his car through Ford Credit. So I would sue John Smith and I would also sue Ford Credit. The only thing Ford Credit is going to have to pay is that which John Smith cannot pay. So if John has $500,000 in insurance, John's insurance coverage will pay first. Once that coverage is exhausted, then Ford Credit's insurance company would have to kick in. The other exception is that Ford Credit's exposure is capped at $1 million. So if John Smith had $1 million in insurance coverage, there would be no need to sue Ford Credit because it is not responsible for paying anything over and above the $1 million. So again, so long as there's $1 million in coverage, there is no claim against the lessor. There would be a claim against the lessor if there was less than 1 million. So if, for example, John Smith had 500,000 in coverage, but the only thing Ford Credit would have to pay is the difference between 1 million and 500, so the remaining 500,000. Now, these exceptions, however, would not apply if there's a separate tort that can be advanced against the lessor. So if you can establish the lessor leased it to someone with a history of poor driving, or a history of failing to pay insurance, or they failed to repossess the vehicle when they found out that the lessee didn't have insurance on it. If there is some sort of a separate tort you can bring against the lessor or Ford Credit in the John Smith example, then they would be on the hook for their maximum exposure, which could exceed the $1 million cap. So the $1 million cap only applies if the lessor is liable vicariously. If the lessor is liable for some other reason independent of the driver and owner's actions, then the lessor is on the hook as if it was a regular tort claim advanced against it. All right, so the next type of defendant would be the unprotected defendant. And I've given you two examples, the first being road authority cases where, for example, the municipality fails to reasonably maintain the roadway. So if it fails to shut the EC Row Expressway down when it knows it's in a state of disrepair during a bad snowstorm, or it fails to properly salt or sand or plow the roadway in the midst of a snowstorm. Those are cases where you would include the municipality. Social host liability relates to bars and overservice. So if you know an individual driver was overserved alcohol at the bar, or even the plaintiff was overserved alcohol and drove their vehicle intoxicated, causing a collision, the tavern could be liable for that conduct. And the tavern could both be liable for some of the plaintiff's contributory negligence for overdrinking him or herself, as well as for the liability of the at-fault driver if he or she was intoxicated. Now, as plaintiff counsel, I like these types of cases because municipalities and taverns tend to have more than $1 million in insurance limits. So if I have a seriously injured plaintiff, I will often look to other pockets to claim their damages from, because you want to make sure that the plaintiff is put in the place he or she would have been in but for the collision. So let's look at both of these types. We'll start first with the road authority case. So again, with respect to municipalities, the majority of cases encountered deal with, failure to salt or sand roadways. I've dealt with ones where the municipality failed to trim trees that were blocking stop signs so that they were not visible. We've had cases where the municipality failed to put rumble strips in when it was recommended, that sort of thing. So what we're looking at is the target defendant as being the local municipality or the provincial crown, depending on which is charged with responsibility for maintaining the roadway in question. So you've got to really take a look and see who has responsibility over the particular roadway. Now, municipalities do have an obligation to ensure that their citizens are reasonably safe. They cannot ignore hazardous weather conditions. And in particular, they're required to monitor the weather and salt and sand their roadways or address the road conditions in a proactive manner. That could also include closing the road as well. Now, Section 44 of the Municipal Act imposes liability on a municipality if it fails to adhere to these obligations. So 44 subsection 1 indicates that the municipality has jurisdiction over a highway or bridge and shall keep it in a state of repair that is reasonable in the circumstances, including the character and location of the highway or bridge. So certainly if it is a busy highway, there is a higher onus on the municipality to do more than if it is, for example, a rural road that is not often traveled. In terms of liability, a municipality that defaults in complying with its obligations to keep the roadway in a state of repair that is reasonable is liable for all damages any person sustains because of the default. Now, it's important to know that with the minister's or the municipality's liability, there are restrictions. They are not by any means held to a standard of perfection. First and foremost, they must have been aware of the dangerous condition through either actual knowledge or deemed knowledge, such that they should have known had they been taking reasonable steps. If they're not aware of the dangerous condition or should not have been aware of the dangerous condition, then there would be no liability imposed on them. Similarly, their only obligation is to take reasonable steps to correct the dangerous condition. So if, for example, they salted a reasonable number of times and the ice remained, they are not likely liable. Their obligation is not to rid the world of icy roads. Their obligation is solely to reasonably address icy roads, as an example. Now, in the case of R.V. Cote, it's a 1976 Supreme Court of Canada decision. The court looked at the liability of municipalities and indicated that there is no general duty for municipalities to salt or sand highways, and their failure to do so does not automatically expose them to civil claims. Recovery against a municipality rests instead on much narrower grounds. There must be a highly special, dangerous situation at a certain location in the highway. The court went on to say the impugned act or omission lay in permitting to continue for some hours a treacherous, slippery, and dangerous icy condition upon a short stretch of much traveled highway with a known tendency to ice up. And the court said, it would seem to me that a reasonable person familiar with Canadian winters should have anticipated a vehicle collision or collisions as the natural and indeed probable result of such a condition of manifest danger. So in essence, what this case is saying is that there must have been a highly dangerous situation. It has to be more than the municipality didn't get there fast enough, because we have to remember that a municipality has a lot of roadways within its jurisdiction and has only a limited budget. So the courts have given allowances for the municipality to be able to address all of those roadways. Now, a municipality is, of course, an unprotected defendant. And what that means, and the same applies for taverns, is that municipalities do not have the benefit of the deductible. They do not have the benefit of collateral deductions, and they do not have the benefit of the threshold. None of those things apply to them. Now, when a claim is brought against a municipality, most municipalities will raise a policy defense. In essence, what they say is that they are not liable in circumstances where their action or inaction is as a result of the adoption of a policy to carry out its statutory obligations. So, for example, they do have an obligation to obviously salt or sand icy roadways, but if their policy is such, that they choose roadway X over roadway I because roadway X is busier than roadway I, that may be a way for them to get out of liability here because the adoption of their policy was reasonable in the circumstances. Now, the Supreme Court of Canada commented on this in the Just and British Columbia decision from 1989, wherein the court said true policy decisions should be exempt from tortious claims so that governments are not restricted in making decisions based on social, political, or economic factors. However, the implementation of those decisions may well be subject to claims in court. And so, what the court was getting at there is that the decision itself may be exempt from tortious conduct, but if the municipality didn't follow through with the decision, so for example, let's say they were supposed to salt road X, Y, and then road Z, and for some reason they skipped road Y and went straight from X to Z, then they very well could have been liable. Now, Section 44, subsection 3 sums up a lot of what I've just indicated. So just to recap, a municipality is not liable for failing to keep a highway or bridge in a reasonable state of repair if A, it did not know and could not reasonably have been expected to know about the state of repair. B, it took reasonable steps to prevent the default from arising. Or C, at the time the cause of action arose, minimum standards applied and those standards were met. Now, municipalities have, and the government has set these minimum standards to indicate what is expected of municipalities. And so long as they meet the minimum standards, they will not be deemed liable. If you think about a municipality, for example, they have numerous sidewalks and roadways that they are responsible for, and they only have so much in their budget to be able to address the safety of the roadways and the highways. If you think of a homeowner, for example, they have a finite amount of sidewalk that they're required to shovel, they can see it out their front door. While the people that are making the decisions for the municipalities can't look out their office and see every single roadway or sidewalk within the municipality. And so because of that, there needs to be, some guidance given to a municipality as to what is expected. That is in essence what these minimum standards are meant to do. And so long as the municipality, as I said, meets these minimum standards, they will be deemed to have discharged their duty. Section 44, subsection 8 of the Municipal Act indicates or talks specifically about untraveled portions of the highways, and in essence indicates that an action cannot be brought against a municipality for damages caused by disrepair or other problems along the untraveled portions of the highway. So this would include problems with any wall, fence, rail, or barrier along the highway. It also talks about construction, obstruction, or erection of any siting, or arrangement of any earth, rock, tree, so on and so forth. So I had a woman contact us about a motorcycle collision she had. It was a pretty bad collision. She lost control of her bike while she was traveling, and there was some gravel on the road. She lost control of her bike and attempted to turn out to the left at what she thought was a flat field thinking that it would cushion the blow for her to land in the field rather than landing on the roadway. Well, what she didn't see was a very deep ditch between the road and the field. And when she attempted to reach the field, the bike hit the ditch, causing her to fly off the bike. It was a horrible collision. She had a number of fractures throughout her body and was really very, very seriously injured. We looked into suing the municipality for the ditch, and we were trying to find some liability on their part for lack of signage, the depth of the ditch, so on and so forth. But all of our experts said they really couldn't find anything wrong with them. And I think that claim likely would have been contrary to subsection 8, which prevents exposure for those untraveled portions of the highway. Now, let's look at the minimum maintenance standards. And again, these are the standards that were set in place to instruct municipalities on what they should at least be doing and to prevent liability for doing at least these minimum standards. So again, so long as the municipality meets these standards, there is likely no liability on their part. So subsection 3 deals with patrolling, and it sets out the frequency required for a municipality to patrol its highways to check for various conditions. This means that or relates to municipal workers driving around the city, for example, and checking on the conditions of its roads. You will often see them doing that in the warmer months. I would argue that they should also be doing it in the colder months because there can be road conditions during the colder months, which certainly can cause a hazard. It also relates to weather monitoring, where they need to monitor their roadways for probability of snow, accumulation, ice formation, icy roads, that sort of thing. Now, the city does have, as I said, a duty to check on its roads throughout the year. This duty is even greater if the city knows about a potential hazard. So I had a case where the city failed to trim a tree that was obstructing a stop sign. And the defendant in my case claimed that she couldn't see the stop sign because of the obstruction that the tree caused. And when I did a Freedom of Information request and obtained the city documents detailing this particular roadway and stop sign, I found that less than a year prior, the city had to trim the tree because it was obstructing the stop sign, and there were complaints at that time. And the city failed to continuously monitor that tree and stop sign. And so we were able to effect a settlement with the city because of that situation and the likely exposure and liability on their part. So subsection 3 of section 3 of the minimum maintenance standards regulation defines what patrolling means. And basically what it means is to observe the conditions of the road either by driving on them or by electronic monitoring. It doesn't apply in respect of other conditions that are outlined in other sections of the regulation. Now, with respect to patrolling, it also sets out how often patrolling is required. And this table outlines the frequency of the patrolling that is required, and it's linked to the class of highway. So again, the more regularly traveled highway, the more frequent patrolling is required. So if you are dealing with a class 1 highway, the patrolling frequency is 3 times every 7 days. And you can see how it changes as you go down in terms of the class of highway. the next element of the minimum maintenance standards is weather monitoring. And the road authority has a duty to monitor the weather, both the current weather as well as what is forecasted to come. They cannot just sit back and wait for the weather to happen. They are required to stay on top of what is about to happen. And so often you will see municipalities, monitoring AccuWeather forecasts and sending out salt trucks, for example, in advance of a snowstorm to prepare for it. This is certainly what is required in the minimum maintenance standards. The frequency of the monitoring of the weather, however, will depend on the time of the year. So, obviously greater weather monitoring is required from October to April when there is likely to be snowfall. In the warmer months, there would be less need, at least in our jurisdiction, for there to be weather monitoring. Now, per the minimum maintenance standards, you can see that between October 1 and April 30th, weather monitoring is to be done once every shift or 3 times per day. And so again, the County of Essex will use the AccuWeather to do this. And when I do request productions, I will get the AccuWeather reports that they did pull during those shifts. Between May 1 and September 30th, so the warmer months, the weather monitoring is only required once every calendar day. Now, Section 4 deals with snow accumulation, and what it refers to is when and how quickly the municipality is required to clear snow accumulation. And it sets out the minimum standards with respect to this. And Section 4, subsection A indicates that the minimum standard, after becoming aware that the snow accumulation on a roadway is greater than the depth set out in the table, which we'll look at in a minute, the municipality is to deploy resources as soon as practicable to address the snow accumulation. And then also it indicates that after the snow accumulation has ended, the municipality is to address the accumulation so as to reduce the snow to a depth less than or equal to the depth set out in the table. And it's really important that they get to this. And this is why you will see municipalities first addressing the main thoroughways. So, EC Row Expressway, Huron Church in Windsor, Howard Avenue. So they first tackle those main roadways. And then the roadways in the subdivisions get tackled later because they are less traveled roads. This is the table that applies to snow accumulation. And if the snow accumulation on a roadway is less than or equal to the depth noted on the table, the roadway is deemed to be in a state of repair. So if we are dealing with a Class 1 highway and it has a snow accumulation depth of 2.5 centimeters or less, it is deemed to be in a state of repair. The time requirement is the time given to the municipality to address that roadway and bring the depth down to the depth that's noted in the table. So on a Class 1 highway, they do have 4 hours to address it. The next aspect of the minimum maintenance standards is ice formation on roadways and icy roadways. Ice formation and snow accumulation are treated differently in the standards. They certainly do result in different road conditions and need to be addressed by a municipality differently. Section 5 of the regulation outlines the minimum standard for the prevention of icy roads. It mandates that the municipality is to do the following in the 24-hour period prior to an alleged formation of ice. So it goes along with their obligation to monitor the roadways and anticipate what is to come. So the municipality is to, number one, monitor the weather in accordance with Section 3.1. It is to patrol in accordance with Section 3. And if the municipality determines that there is a substantial probability of ice forming, they are to comply with the times set out in the ice formation table for deploying appropriate resources. And this really goes to the salting and sanding that is required to improve the road conditions. If the municipality meets the minimum standard and ice still forms on the roadway is deemed to be in a state of repair until a couple of things happen. One, the time the municipality becomes aware of the ice, they must act once they become aware of the ice. So if they did all of the minimum standards and they're notified that there is still ice on the road, they still have an obligation to do more. They must act to respond to that condition. They can't just ignore it and say, look, I met the minimum standards, I'm done. They do have an obligation if they know there is ice there. And so because of this, when I'm dealing with a municipal claim, I will often ask for any complaints that were logged dealing with the road conditions or the sidewalk conditions. Or the second aspect where there would still be liability is if the applicable times in the table for treating ice expire. So the municipality is not expected to be able to respond to every complaint of ice immediately. They are just expected to respond within the appropriate timelines, and it's important that they, at a minimum, comply with the timelines in the table. Now, subsection 3 just indicates that the municipality must treat the roadway within the appropriate timelines that are set out in the table, which we will look at in a minute. And it is not deemed to be in a state of repair until the particular time set out in the table expires. Subsection 4 indicates that the municipality must apply material to the roadway to improve the condition. That would include salt and sand in order to address the ice formation. This is the table that sets out the minimum standards with respect to ice formation. So if it is a Class 1 highway, for example, the municipality is required to respond within 3 hours. And that 3-hour time period starts when the municipality determines that the road has or should have determined that the road has a substantial probability of becoming icy, or within 3 hours of becoming aware that the road is in fact icy. So again, the busier the road is, the faster the municipality is required to respond to it. There are additional maintenance standards that apply. We're not going to go through these in any great detail in this course. I think the minimum maintenance standards could be a course in and of themselves. I've highlighted the key ones for you, but this slide just outlines the other types of standards that exist and the various section of the regulation that deals with them. I do not need you to go and read each of these for the purposes of the course, but if you are practicing in this area, you should be aware of them. There certainly could be issues with respect to the maintenance of potholes, shoulder drop-offs, cracks in the roadway, debris, lights, signs, so on and so forth. Now, if you are going to sue a road authority or you are representing a road authority, these minimum maintenance standards will be your primary resource. You will need to familiarize yourself with the standards in order to be able to assess whether or not the municipality was in fact negligent. Now, let's talk about the second type of unprotected defendant that you may wish to include in your tort claim. This relates to commercial or social host liability. And here we're really dealing with the bar or the tavern for having overserved the at-fault driver. So I had a case, really interesting case, where my client went out with his ex-girlfriend and two of his buddies. And so the four of them were out. They were at a local bar out in the county, and they had all drank much too much. The girlfriend was dancing on the tables at one point. She was, behaving inappropriately in that she was lifting her top. They were loud, and they just kept buying drinks, and the bartender wasn't doing anything in order to monitor the types of drinks or the amount of drinks that they were having. The bartender also wasn't doing anything to ensure that they were eating while drinking. And when I questioned the bartender for discovery, his response to me was, well, they seem to be having a good time, so I just left them be. Well, by letting them be, he also let them leave the bar and get into a vehicle, and they ended up leaving in two separate vehicles. Neither of the drivers were likely sober enough to be driving those vehicles, and they then drove their vehicles to a second bar. And at this second bar, they drank some more. In fact, the bartender at the second bar sold them a six-pack of beer and left them on the patio while she closed the bar and left. So there's now these four intoxicated people sitting on the patio of a bar with a six-pack of beer and two cars. What ended up happening is my client and his ex-girlfriend got into an argument. The ex-girlfriend tried to leave, but she was so intoxicated she didn't realize that my client was standing near her vehicle and that the wheel was turned, and she ended up striking my client in the parking lot, causing him to fall to the ground. Because he was so intoxicated, his head hit the gravel on the ground. He did not break his fall. He ended up with a number of facial fractures, a very severe head injury, as well as fractures to, I believe it was his ankle from the wheel, we think, traveling over his foot. So it was a pretty bad accident. It's probably, one of the most egregious stories that I've heard in terms of the liability of these two bartenders. They both certainly had some responsibility for what happened here. With social host or commercial host liability, there's also an argument that, the plaintiff and the defendant both agreed, decided to drink of their own free will and bear some of that responsibility for them as well. So what typically happens in these cases is at the end of the day, everybody's responsible. So the two bartenders are responsible, and the driver and plaintiff is responsible. And so the question in these types of cases often becomes, how do you divvy up or divide up the liability? So on a scale from 0 to 100%, how much is each party liable for? There is a positive duty on taverns and bars to make their premises reasonably safe for persons entering on it. And they have to make it reasonably safe from foreseeable harm. So, certainly there has to be something that they could have otherwise prevented. And so often you'll be questioning the bartenders on, what were the signs of intoxication? Should the bartender have done something differently or realized that the individual was intoxicated? Because there are a lot of individuals who are heavy drinkers and can drink a lot before a stranger may realize that they are in fact intoxicated. And so the smart serve rules, for those of you who have worked in the service industry, those smart serve rules are really important, and they really do form part of the questioning at an examination for discovery. Now, the civil liability on servers and their employers for overservice emanates from, first and foremost, the Liquor License Act. Section 29 of the Act forbids the sale of liquor to any person appearing intoxicated. And then Section 39 of the Liquor License Act imposes civil liability for damages the person causes to himself or others if the bar overserved the individual. And this section basically permits a tort claim to be brought against the bar and its employees. And specific questions that would be asked of the tavern, is, did the bar take any steps to prevent overservice? Did the bar assess the intoxicated person before he or she left the bar? Should the bar have reasonably known the individual was intoxicated? Did the bar take reasonable steps to prevent the individual from leaving the bar or driving? So, going back to that egregious case that I told you about that I had, before these 4 clients, while they were at the first bar, the bartender should have been assessing the number of drinks they were each having. And servers really do have an obligation to keep track of the drinks the individual is serving. It's not a bottomless pit that continues to be filled. There needs to be monitoring of the drinks. The bartender also, it was a relatively small bar. There were only a couple of other people in the bar. The bartender should have been having a conversation with them before they left to determine if they were capable of driving. And if they weren't capable of driving, the bartender obviously does not have to put himself in harm's way, but he does have an obligation to offer them a cab, to call the police if they enter their vehicle in an intoxicated state, to do whatever it is that the bartender can reasonably do to prevent harm to these individuals or others if they get into a vehicle on the roadway. In addition to the liability that's found in the Liquor License Act, there is also the Occupier's Liability Act that applies. And Section 3 of the Act mandates that an occupier of premises has a duty to ensure that all patrons are reasonably safe while on its premises. So the bartender has a duty not only to prevent overservice, but to prevent safety of these individuals. And that would, go to bar fights, to having proper security, to monitoring them before they get into a vehicle. And that duty would apply in addition to the duty that's found in the Liquor License Act. So if you were advancing a claim on behalf of an injured party where you were suing a tavern, you would more likely than not want to plead both the Occupier's Liability Act and the Liquor License Act in your pleadings. With respect to the Occupier's Liability Act, the case law has determined that occupiers have an affirmative duty to make the premises reasonably safe. They must do something. Nothing will not suffice here. They do have an obligation to do something. And so again, though, that obligation, similar to municipalities, is to only take such care as is reasonable in the circumstances. So a bartender is not required to tackle an intoxicated person to prevent them from driving, but the bartender is required to offer to take a cab, to stop service of alcohol, to, call the police if the person continues to leave and gets into their vehicle. There is an obligation to do something. And often with these occupier liability cases, what we're looking at is what system did the tavern have in place to monitor the number of drinks and check for signs of intoxication. And that's really what it boils down to, is there must be a system, and that system must be followed. Stewart and Petty is one of the leading cases dealing with tavern liability. It is it sort of follows the Jordan House decision, which is a 1973 Supreme Court of Canada case. And Jordan was the initial case of overservice where an individual was served to the point of intoxication. The tavern allowed that individual to walk home. He was then struck by a car while walking home. In that case, the court found that the tavern had a duty to ensure its patrons got home safely, and that duty meant to offer the individual a ride, or a taxi type service, and that the tavern was not to let the patrons simply walk home. Stewart and Petty was the first pronouncement by the Supreme Court of Canada on whether the duty of care existed between the tavern and members of the general public. So in the Jordan House case, the issue before the court was whether was the duty between the tavern and the person the tavern overserved. In Stewart and Petty, the court looked at the duty between the tavern and people the person who was served may come into contact to. So in Stewart and Petty, the person who was overserved then got into a vehicle and drove drunk. And the question for the court was, did the duty of care the tavern had extend to a plaintiff who was injured by that drunk driver? That plaintiff didn't set foot in the tavern and was not served by the tavern. And what the court confirmed in Stewart and Petty is that a duty does in fact exist. The tavern owes a duty to every individual the drunk driver may come into contact with on the road. The duty was extended to the general public on the basis that there was a sufficient relationship of proximity between members of the public and liquor serving establishments. And you can see that it is, as they call it, a logical step to find this duty of care to extend to the public. And highlighted in bold and underlined, the court said, it is the same problem which creates the risk to the third parties as creates the risk to the patron. By overserving the patron, the bar is creating a risk both to the patron and to members of the public if the patron drives drunk. And the court went on to say, if the patron drives while intoxicated and is involved in an accident, it is only chance which results in the patron being injured rather than a third party. The risk to third parties from the patron's intoxicated driving is real and foreseeable. Now, keep in mind that liability of a tavern, though, does not flow automatically from a statutory breach. So it's not enough to prove that the tavern overserved the individual. You must also prove that the overservice or the harm that was caused to the plaintiff was a foreseeable risk. And the onus of proving that rests on the individual. Basically, what the injured plaintiff is required to prove is that there was a foreseeable risk that the individual would be injured, and the onus, and therefore it placed that foreseeable risk, placed an onus on the tavern to take positive steps. There's a two-step test. Number one, is the tavern required to take positive steps? And number two, if so, are the steps taken sufficient to discharge the onus placed on the tavern? So in the case that I had, that egregious case, I had to establish that the bartender knew or ought to have known that the patrons were intoxicated and would leave in a vehicle. And so, looking at the facts of the case, I looked at things with like the female patron dancing on the table and raising her top, and all four patrons being loud, and the number of drinks that they consumed compared to their body weight. Through all of that, I was able to establish that it was foreseeable that these patrons very well would be intoxicated. We also looked at the fact that they would likely be driving. They arrived in a vehicle. They were in a rural area where there wasn't much place for them to walk to. That sort of thing to prove that that risk was foreseeable and the bar should have taken positive steps. And once you establish that the bar should have taken positive steps, you then look at what the bar actually did and whether or not those steps were sufficient. So to sum it up, positive action on the part of the tavern is only required where it is reasonably foreseeable that an intoxicated patron represents a risk of harm to themselves or others. Another interesting thing about commercial and social host liability is the impact of the tavern's overservice on the percentage of contributory negligence on the part of the plaintiff and on the liability of the driver. Because when you think about an accident involving an intoxicated driver, it's the intoxicated driver that causes the accident in that he or she is the one behind the wheel. And so how do you sort of apportion liability amongst all the various parties? And if a plaintiff, for example, is contributory negligent, so in that case I had, the plaintiff, for example, was unable to break his fall because he was so inebriated, is that the plaintiff's fault, or is that contributory negligence the fault of the tavern? So, what typically happens in these types of cases is the jury first has to decide, are all the parties at fault? So is the driver, the tavern, and the plaintiff, do they bear any liability? And then they have to apportion the liability on a scale of 0 to 100%. Most taverns are typically found to be no more than 20% liable for overservice. That tends to be the trend amongst the cases. So if we take a look at the Pilon case, which I have up on the screen, and this is it's a 2006 Court of Appeal decision, and the court here discussed how a jury is to apportion liability amongst the various parties. This is a case where the defendants collectively admitted 100% responsibility for the collision, subject to any reductions for contributory negligence on the part of the plaintiff for failing to take reasonable precautions for his own safety by, for example, becoming intoxicated, and in this case, accepting a ride with an intoxicated driver. So in terms of the facts, we're dealing with both a plaintiff and defendant who were both overserved. And the defendant was intoxicated. The plaintiff accepted the ride with the defendant. And then there was a collision in which the plaintiff was injured. And so the jury had to assess, how do you apportion liability amongst the defendants, which included the tavern and the driver, as well as amongst the plaintiff. And in this case as well, the plaintiff was not wearing his seatbelt. So the jury found at the trial level that there was 17.5% responsibility for the collision on the part of the plaintiff for failing to take account of his own safety and drinking. The jury also found that the plaintiff was 18% responsible for failing to wear his seatbelt. Now, the reason that the case was ultimately appealed to the Court of Appeal was in part because the jury was not asked to determine to what extent the tavern was responsible for the plaintiff's overservice. So more specifically, to what extent did the tavern cause, by overserving the plaintiff's contributory negligence? So the issue for appeal was what about the tavern's percentage of responsibility for the plaintiff's contributory negligence? And they had to look at how that should be assessed by a jury. And the Court of Appeal found that the tavern was partly responsible for the plaintiff's contributory negligence because the tavern had overserved him, and thus the contributory negligence that was assigned to the plaintiff should be reduced by the amount to which the tavern contributed to it. And that reduction should then go over to the tavern. In this case, the tavern breached its duty not only to the driver who caused the collision because he was intoxicated, but also to the passenger who was injured by over-serving him, which again caused or contributed to the injured party's lack of judgment in accepting a ride with a drunk driver and ultimately failing to wear his seatbelt. So the Court of Appeal went on to order that the liability of the tavern, in essence, serves to reduce the percentage of contributory negligence for the plaintiff. And you can see at the bottom of the screen the tests that must be applied when you're dealing with these types of cases. So the court held that the tavern is liable for its breach of duty for overserving both the driver and the passenger. And when the trial judge gave the jury instructions, the jury should have been asked to apportion responsibility for the defendant's damages or for the party's damages in 4 parts. First and foremost, to the driver and owner of the vehicle. To what degree are they responsible? 2, to the injured passenger for his contributory negligence. 3, to the tavern for overserving the driver, and 4, to the tavern for overserving the passenger. Now, this is a relatively, complicated case to understand, and so I've added a slide. This slide was not included in the original PowerPoint because typically I would draw on the board for this part. So I've added this slide. This is new. And if you look at the chart, we've got a case where we're dealing with a defendant driver, a plaintiff, and a tavern. And so the jury needs to look at all 4 parts. They need to look at the liability of the defendant driver, they need to look at the liability of the plaintiff, and then they need to look at the degree to which the tavern contributed to the defendant driver's liability by overserving the driver, and the degree to which the tavern contributed to the plaintiff's liability by overserving the plaintiff. So the easiest way to do this is to first look at it as if there's no tavern involved. So we've got, say it's an accident, single vehicle crash where the defendant loses control of his vehicle. The defendant driver is 80% responsible, and they decided that the plaintiff is 20% responsible for example, not wearing her seatbelt. So first, you have to determine the liability of the driver and the contributory negligence of the plaintiff. So that's the middle column. And that percentage should add up to 100%. Then, if you look at the far right column, what the Court of Appeal says is you have to apportion liability to the tavern for overserving the driver and also for overserving the plaintiff. So if we look at the driver first, the jury might decide that the tavern contributed 20% to the driver's liability, which would then reduce the defendant driver's liability down to 60%. And you can see that in the first row. And then that 20% that the tavern contributed to the driver would form the tavern's liability percentage of 20%. Then the jury has to look at to what degree did the tavern contribute to the plaintiff's contributory negligence. And so the plaintiff is 20% contrib. If the tavern contributed 50% to that, it would be a reduction down to 10% on the part of the plaintiff, and then 10% would get assigned to the tavern. So in this case, the tavern would be held to be 30% responsible at the end of the day, 20% because of its conduct towards the driver, and 10 because of its conduct towards the plaintiff. The defendant driver would be 60% at fault, and the plaintiff would be 10% at fault. And you'll see all of those add up to 100%, and that's how the liability would ultimately be apportioned. Now, I know this case can be somewhat complicated, so if any of you do have questions on it, please do not hesitate to email me about them. So to sum up tavern liability, when you're looking at it, you really want to do an analysis of any Alcohol and Gaming Commission policies and bulletins, the Smart Serve protocols, and certainly the Liquor License Act, and make sure that you are familiar with all of those so that you can properly conduct the examination of the tavern representative. Another issue that arises with respect to tavern liability is the potential for punitive damages. And this is not specific to the tavern, it also goes to the defendant driver for operating the vehicle while impaired. The main question here is, should the defendant be punished with punitive damages for driving drunk? And you'll recall that punitive damages are really intended to be those damages that punish someone. In essence, to deter them or deter the public from bad behavior in the future. At common law, punitive damages can be awarded in any civil suit in which the plaintiff proves that the defendant's conduct was malicious, oppressive, and high-handed, such that it would offend the court's sense of decency. Punitive damages are available in motor vehicle accident cases that involve drinking and driving. Now, we can all agree that drinking and driving is extremely dangerous, and it is an activity that attracts great public outrage. Many would argue it's very much deserving of punishment, and it is something that is completely avoidable. In McIntyre and Gregg, the Court of Appeal considered for the first time whether or not punitive damages should be available in the context of a motor vehicle accident case, particularly with respect to drinking and driving cases. In this case, the plaintiff was walking along a curb with her friends after leaving the University of McMaster pub. She was struck by a vehicle operated by an impaired driver. The plaintiff suffered a closed head injury, soft tissue injuries, as well as orthopedic injuries. She continued to experience significant pain and numbness. She had restricted range of motion, and she had permanent scarring 6 years after the accident. Her athletic career was drastically compromised. She also suffered from a major depressive disorder, and her depression actually led to 2 suicide attempts, which required her to be on medication for the rest of her life. This case went all the way up to the Court of Appeal, and the court had to really look at whether or not punitive damages should be available. At the trial level, the jury found the defendant driver to be 70% liable and the pub 30% liable as a commercial host. The jury also awarded $100,000 in punitive damages as against the pub. Now, the pub then appealed the decision. On appeal, the Court of Appeal considered, among other issues, the jury's award of punitive damages, and they looked at, can punitive damages be awarded in drunk driving cases, and was the amount of the award appropriate in this particular case? The Court of Appeal entered into a lot of discussion about punitive damages and specifically its role in a negligence action. The court noted that punitive damages are awarded to meet the objectives of punishment, deterrence, and denunciation of the defendant's conduct. They are not meant to compensate the plaintiff. The court also noted that an award of punitive damages requires the defendant to have engaged in extreme misconduct. Punitive damages are only justified in the most extreme cases, as again, they are designed to express the repugnance of the public, represented by the jury, towards the outrageous conduct of the defendant. The types of misconduct that warrant punitive damages include malicious, oppressive, arbitrary, and high-handed conduct that offends the court's sense of decency. The court indicated that there must be a marked departure from ordinary standards of decent behavior. Harsh, vindictive, reprehensible, and malicious behavior that offends the ordinary standards of morality and decency. It must be egregious, high-handed, and callous. They indicated that it must be highly unethical conduct which disregards the plaintiff's rights and recklessly exposes a vulnerable plaintiff to substantial risk of harm without any justification. Now, in this case, the defendant's excessive drinking and driving is what caused the collision. And the court concluded that the defendant showed a conscious and reckless disregard for the lives and safeties of others, and held that punitive damages are in fact appropriate in these circumstances. Although this case, Barber and VROZOS, is not a case about drinking and driving, the Court of Appeal in the Grigg decision followed the reasoning in Barber. And in Barber, the court indicated that in determining whether the threshold has been met, it is not necessary to show that the defendant's conduct meets one or several of the above adjectives, so specifically the reckless, the malicious. You don't have to show that it meets one of them, but the analysis must instead focus on whether the conduct in question is so serious that it engages the policy goals that underlie punitive damages. In the Grigg decision, the Court of Appeal held that negligent conduct can only attract punitive damages if the misconduct in question was intentional and deliberate and was extreme in nature, such that by any reasonable standard it is deserving of full condemnation and punishment. The court rejected the defendant's argument that an award of punitive damages requires the defendant's conduct to be specifically directed at the plaintiff. So the defendant's argument was, in essence, that he didn't set out to run down the particular plaintiff. The court said that doesn't matter. The fact that he did not take care for the safety of the general public was sufficient to warrant an award of punitive damages. The court reasoned that it would be inappropriate to narrow the scope of punitive damages by specifically requiring that the defendant's conduct be directed at the plaintiff. And the court found that it is sufficient if there was an intention to do the act or combination of acts that eventually caused the injury. So the fact that the defendant got out and intentionally drove intoxicated was enough, because that intoxicated driving had the potential to cause harm to the general public. The court found that the evidence before the jury in this particular case was sufficient to meet the requirements that the defendant's conduct was deliberate and intentional. His decision to drink excessively and drive, his intoxication, and the evidence that he was speeding and driving erratically were key contributors to the cause of the collision. And they found that all of the factors demonstrated that on the night in question, the defendant showed a conscious and reckless disregard for the lives and safety of others. The court also indicated that other punishments, such as a careless driving conviction under the Highway Traffic Act, which quite frankly attracts very small fines, sometimes typically just $500, that these types of convictions, in the court's view, are not necessarily a bar to a punitive damages award. The court indicated that punitive damages are only to be awarded if all other penalties endured by the defendant have been considered and found to be inadequate to accomplish the goals of deterrence, denunciation, and retribution. So in this particular case, the McIntyre and Grigg case, the court held that it was rational for the jury to award punitive damages and signal the need for the general deterrence of impaired driving, and that it would not amount to double punishment given that the defendant was fined $500 under the Highway Traffic Act. But what the court did do here was to reduce the jury's award of punitive damages. It held that the quantum of the punitive damages was not proportionate to the objectives and ultimately reduced that $100,000 award to $20,000. In terms of future implications arising from this decision, I think it does make clear that punitive damages do have a place in negligence actions involving drinking and driving. They are only to be used in the most extreme cases, but the courts will look at all of the circumstances and consider all of the penalties imposed upon the defendant to determine whether the goals of punitive damages are adequately achieved. The next issue that I want to get into is the vicarious liability of employers. This relates to commercial host liability where, you have a bartender who overserves, but the bartender's employer or the owner of the bar would also be vicariously liable. It would also apply to the situation where you have a truck driver who causes a collision, but his employer would also be vicariously liable. Or if you have someone who's driving during the course of their employment, their employer again would also be vicariously liable. The vicarious liability of employers for the actions of their employees is a tort principle that is based in the common law. There's a seminal Supreme Court of Canada decision. I'll give you the name of the decision. It's a numbered company 671122 Ontario Limited and Sagaz, SAGAZ Industries Canada Inc. It's a 2001 decision. You likely read that decision in your tort class. And that decision requires a two-part test. So first and foremost, there must be an employer-employee relationship, which is distinguished from an employer-independent contractor relationship. There is no vicarious liability when we're dealing with an employer-independent contractor situation. You must look at the reality of the relationship to determine which of these applies, not just what they declare on their income taxes, because as most of us know, what's declared on the taxes is not always what occurs in reality. The second step of the test is that the employee's tort must have been committed in the course of the employee's employment. So in auto insurance claims, this typically occurs when someone is a professional driver. So think of a garbage truck driver or a transport driver or a bus driver. If they commit a tort while driving during the course of their employment, then their employer is vicariously liable for that tort that is committed. Now, there's also the situation of the employer committing an independent tort. So for example, what if you have a transport truck company who hired a driver who they knew was incompetent or who had a suspended license, for example? That would be an independent type of tort. And the employer would not just be vicariously liable for the actions of the driver, but the employer would also be liable in their own right. And similar to the situation with lessors, if there is an independent tort that was committed by the employer, it would make the employer liable for more damages than that for which the driver is liable. So to sum up what we've talked about, you can look on the plaintiff side of this chart. You're always going to include the injured party. You will also look at whether or not there are any Family Law Act claimants under Section 61 of the Family Law Act who should be included. On the defendant side, it's a little bit more complicated. You really do have to think about the case. The driver obviously would be included. The owner of the vehicle, the driver's driving would be included. The lessor, if the insurance on the vehicle is less than $1 million. The plaintiff's own insurer can be included, and that's on account of those uninsured, unidentified, and underinsured provisions that we talked about in a prior class. And then there's potentially others who could be included, such as the municipality or a tavern or the employer. And so you've got to look at the facts of the case and see who is vicariously liable and who may have committed a tort in their own right as well. Now, keep in mind, too, there is entitlement to a jury trial in these cases, but if a municipality is involved, there is no jury. So depending on the individual's damages or injuries, some plaintiffs' counsel will look to get rid of the jury, and by adding the municipality to the lawsuit, that could potentially rid the case of the jury. So that about sums it up in terms of the plaintiffs and defendants. What I want to do now is go into the common defenses that we typically see in these types of cases. There are really two main common defenses. The first is the seatbelt defense. So most defendants will allege that the plaintiff either did not wear his or her seatbelt or did not wear it properly. The second is that it was an inevitable accident, that there's nothing the defendant could have done to, in essence, avoid the accident. Now, remember, liability is determined on a scale of 0 to 100%. So the jury is going to have to apportion liability as between the plaintiffs and defendants. So when they're looking at the plaintiff, they're looking at whether or not they are contributory negligent to the case or to their damages. And Section 3 of the Negligence Act talks about contributory negligence and indicates that in any action for damages that is founded upon the fault or negligence of the defendant, if fault or negligence is found on the part of the plaintiff that contributed to the damages, the court shall apportion the damages in proportion to the degree of fault of negligence found against the parties. And so the court has to take a look at whether or not the plaintiff was in any way contributory negligent. And if the plaintiff was, what is the degree of fault on the part of the plaintiff versus the degree of fault on the part of the defendant. And Section 6 of the Negligence Act indicates that the degree of fault or negligence of the parties is a question of fact for the juries. The question the jury is asked is, did any fault or negligence on the part of the plaintiff contribute to the damages? Now, when looking at fault on the part of the plaintiff, the jury is asked, or the jury is required to find a link between the plaintiff's negligence and the plaintiff's damages or losses. So even though the plaintiff may not have worn his seatbelt, if the injury would have been the same, regardless of whether the plaintiff wore the seatbelt, there may not be contributory negligence in that particular situation. There's, a number of examples of contributory negligence in auto cases. The plaintiff, may have been partly at fault for the collision by having turned in front of another vehicle or failing to signal the plaintiff's turn. or making a rolling stop at a stop sign. Or the plaintiff may have been a pedestrian and didn't cross in the crosswalk or failed to look both ways before crossing the street. Or the plaintiff could have been following a vehicle too closely. In the case that I talked to you about on the first class that I attended, the one where the baby was severely injured, one of the allegations of contrib in that case was that the parents had improperly packed their van and they had stuffed it so tight that when the defendant rear-ended them, it caused the contents of the van to shift and strike the baby. And there's another allegation right there where one of the plaintiffs could be at fault for what happened to the injured party. But the most common argument, and the one we really see in every single case dealing with contributory negligence, is that of the failure to wear a seatbelt or to properly wear the seatbelt. And so let's talk about that first, and then we'll get into the inevitable accident defense. So the Highway Traffic Act, specifically Section 106, requires that seatbelts be used when driving on a highway. It further requires that the driver of the vehicle ensure that passengers under the age of 16 wear their seatbelt or be in a properly secured child restraint system. So if there's contributory negligence for not wearing a seatbelt, the child will not be at fault for that. The driver of the vehicle will be at fault. Now, for years and years, defendants raised the seatbelt defense and argued for large reductions on account of a plaintiff's failure to wear it or to properly wear it. This was particularly the case where plaintiffs would be ejected from a vehicle and suffer very severe injuries. The argument is always that had the plaintiff been seatbelted, the injuries would have been avoided altogether, or at least they would not have been as severe. The defense, in essence, argues that the plaintiff was the cause of his or her own misfortune. In fact, in some cases, the defense has even tried to argue that plaintiffs should be 100% at fault in cases where the use of a seatbelt would have completely prevented the injuries. But the issue with that argument is really this: should the plaintiff's failure to use a seatbelt completely exonerate a defendant whose negligence caused the accident in the first place? So think about this. You could drive from school to your home and not wear your seatbelt, and provided everybody else drives appropriately, you won't be hurt. But if the defendant or some third party fails to drive appropriately and, for example, fails to stop at a stop sign, you would be injured. But why should the plaintiff or the defendant be off the hook? The defendant's the one that made the mistake here. Why should the defendant be fully off the hook when the defendant's the one that caused your injury in the first place? So let me show you an example that I have up on the slide. So think about the case of a rear-end collision. So we have Mark Baker in the black vehicle. He was not wearing his seatbelt. Had he worn his seatbelt, the doctors found that his injuries would have been minor. We've got Joe Smith in the red vehicle. He clearly caused the accident. He rear-ended Baker. And had he not rear-ended Baker, Baker would have been fine. Baker would have made it all the way to his destination without issue. So who's responsible here? Should Mark bear all of the responsibility by not wearing his seatbelt? Or should Joe bear all of the responsibility by causing the collision? Or should there be some combination of the two? This is really a long-standing debate, and most plaintiff advocates would argue that Mark's failure to wear his seatbelt did not cause the collision. It certainly at least was not the primary cause of his injuries. Had the defendant, Joe Smith in this case, not rear-ended Mark's vehicle, there never would have been an accident and Mark would have been fine. So the argument of most plaintiffs' advocates is that the bulk of the negligence should therefore rest with Joe Smith in this case. He is the one who caused the collision. On the other hand, defense advocates or insurance advocates would argue that, but had Mark been wearing his seatbelt, the injuries would have been minor, so why shouldn't he bear the bulk of the responsibility for having failed to wear his seatbelt? Now, for years and years, this debate continued, and there were decisions all over the map. But the debate ultimately came to a head in 2005 when the Court of Appeal heard the Snushel and Fulsang decision. So Snussel and Fulsang is a 2005 Court of Appeal decision. Mrs. Snushel was a passenger in Mr. Fulsang's car. Daniel Fulsang was driving westbound on Taunton Road, approaching an intersection. His car was equipped with lap belts and a separate shoulder harness for the driver and the right front passenger seat. The middle front seat was equipped with a lap belt. Carol Snushel, who is the plaintiff, was only wearing her lap belt. Her evidence was that she did not know that there was a shoulder belt available. She ended up suffering some very serious injuries. She had a burst L3 fracture necessitating a spinal fusion surgery. She suffered a closed head injury that resulted in permanent cognitive impairments in the areas of concentration, information processing, and multitasking. What the jury was asked to decide was whether or not Mrs. Snushel was contributory negligent for failing to wear a full seatbelt assembly which was available to her. At the trial level, the jury found that Mrs. Snushel was 35% contributory negligent, and they found that her injury would have been prevented by the use of the shoulder belt. The interesting thing is, as many of you probably know, before a jury goes into the deliberation room, the judge will give a charge to the jury where the judge will explain to the jury what their duty is and basically what the law is with respect to that duty. And when the judge gave the jury their charge or their instructions, the judge indicated that the usual range for contributory negligence because a plaintiff had not worn a seatbelt is 0 to 25%. The interesting thing here is that the jury imposed a higher percentage of contributory negligence on Ms. Snushel, putting her at 35%, which is outside that 0 to 35% range. And the question for the Court of Appeal, Mrs. Snushel obviously appealed, is should Mrs. Snushel bear 35% of the liability? Now, when the Court of Appeal looked at the decision of the jury, it agreed that it was reasonable based on the evidence for the jury to find contributory negligence on the part of Mrs. Snushel. But what the court did disagree with the jury on was the finding of 35%. The court held that it was beyond the scope of anything that could be accepted as reasonable on the record in the particular case, and that award of 35% exceeded the appropriate assessment by more than 50%. The court went on to discuss what a finding of contributory negligence is and its relationship to the defendant's negligence. And what the court said is the plaintiff was injured because of the defendant's negligence, not because the plaintiff failed to wear a seatbelt. Had the defendant not rear-ended the plaintiff's vehicle, there would be no injuries, regardless of whether or not the plaintiff wore her seatbelt. The court held that the defendant's negligence is, in fact, the cause of the injuries. It initiated the sequence of events that led to the damages the plaintiff suffered. Now, the fact that the plaintiff did not wear a seatbelt is different, the court found. The accident would have occurred regardless of whether or not the plaintiff was wearing her seatbelt. all the seatbelt would have done was to prevent or help prevent the consequences that arose from the defendant's negligence. And so the court held that failure to wear the seatbelt only contributed to the extent of the plaintiff's injuries. It did not cause the injuries. So what the court then did is it reviewed the previous cases and it noted that the trial judge was very much correct in the usual range of being 0 to 25% for contributory negligence. And the court went on to make it clear that the maximum percentage of contributory negligence for failure to wear a seatbelt should be 25%. And here I'll read what the court said. It would be preferable to instruct the jury that where contributory negligence is found only for not wearing a seatbelt, its award should fall within a range of 0 to 25%. That is, the upper limit of the range, that is 25%, is only available in those cases where the jury is satisfied that substantially all the damages could have been prevented by wearing a seatbelt. So for a range of, or an amount of 25% to be assessed against a plaintiff, the evidence must be clear that substantially all of the damages could have been prevented by wearing a seatbelt. And so for that reason, often what the parties will do is obtain engineering evidence to talk about the force of the impact and what a seatbelt could or could not have done, because the vast majority of cases will fall below that 25% range. And the court went on to say where the evidence does not establish that all the injuries would have been effectively prevented, the allocation of contributory negligence should therefore be less than 25%. And that was the case in the Snushel decision, is all of the injuries would not have been prevented by her wearing the lap belt. And so because of that, the range of contributory negligence ought to have been less than 25%. In these types of cases, if the defense is going to raise a seatbelt defense, the defense has the onus, the burden of proof is on them to establish that the injuries would have been less if the seatbelt is worn. It is not enough for a defendant to say the plaintiff did not wear the seatbelt, therefore there must be a reduction. They do have to put forth evidence that the plaintiff's injuries would have been less had the seatbelt been worn. Now, the conclusion really here is that the negligence of the defendant is the cause of the accident and the primary cause of the injuries. The defendant must therefore bear the greater share of responsibility. The range for contrib is 0 to 25%. It cannot be more than that, and only cases where the evidence establishes that all of the plaintiff's injuries could have been prevented will the 25% number apply. So in this case, what happened was the court set aside the jury's verdict and found that Mrs. Snushel's contributory negligence was only 5%. Now, there are other cases where the issue of contributory negligence arises. So think of, for example, a motorcycle accident or a bicycle accident where the plaintiff wasn't wearing a helmet. The failure to wear a helmet is akin to the failure to wear a seatbelt. And so the principles that apply in the Snushel decision would certainly extend to those cases as well, where if a plaintiff fails to wear a helmet while on a bicycle or on a motorcycle, the range of contrib would also be limited to 0 to 25%. There are no cases specifically on that point, but it certainly is an easy flow from the Snushel decision. Now, I've touched on this already, but just as a reminder, where a plaintiff is contributorily negligent, that percentage of negligence will also apply to the Family Law Act plaintiffs. Because again, the Family Law Act claims are derivative of the injured party's claim. So whatever happens to the injured party's claim will also happen to the Family Law Act claim. Section 61, subsection 3 of the Family Law Act deals with this and indicates that the right to damages is subject to any apportionment of damages due to contributory negligence of the person who was injured or killed. So if the plaintiff is 20% responsible, or the injured plaintiff is 20% responsible, so too will be the Family Law Act claimants. Their damages will also be reduced by 20%. Now, the other common defense that I mentioned is that of inevitable accident. And so let me give you an example. I had a tragic case where an elderly man was driving in his own lane. He really didn't do anything wrong. A transport truck driver lost control of his transport truck, caused it to roll and fall. It ended up rolling onto the elderly man's vehicle, and the elderly man unfortunately passed away. What we learned through the discovery process and the production of documents is that the driver of the transport truck had a heart event where he, in essence, went into cardiac arrest. And the condition that he had caused him to, it's a little more complicated than I can probably explain here, but basically caused him to pass out. And that's what happened. And as a result of that, he lost control of his vehicle. Now, the defendant tried to raise this inevitable accident defense and said, he passed out, he had this heart event, there was nothing he could have done to avoid the accident. Unlike the seatbelt defense, the inevitable accident defense is a complete bar to the plaintiff's recovery, such that if the defense is successful, the plaintiff will not be able to recover any damages from the defendant. Now, when I looked at the discovery evidence and I looked at the defendant's prior medical records, what we did notice is that the date of the accident wasn't the first time that this particular heart event happened to the defendant driver. It had instead happened previously. He had missed a medical appointment that he was supposed to attend, and he hadn't eaten properly that day. And so because of that, I had a number of arguments that this was not an inevitable accident. There were things that the defendant could have done to specifically prevent the accident. Now, inevitable accident is basically defined as an occurrence that is not avoidable by any steps or precaution that a reasonable person would be expected to take. And remember, the key here is reasonable person. It is not enough to say there was nothing this particular defendant could have done. The court will look at whether or not the accident could have been avoided by a reasonable person. The test that the court looks at has two parts to it. First, actually, before that, the defendant who puts forth this defense has the burden of proof. So the defendant must prove both parts of these tests. Step one is that something happened that was completely outside the defendant's control. So in the case involving my trucker, the trucker had a heart event that he said was completely outside his control. Second part of the test is that the effect of the occurrence could not have been prevented by the greatest of skill and care. And so in the trucker's case, he said that there was nothing he could have done to prevent this. It came about suddenly. He didn't have advance warning, and there really wasn't anything that he could do. Now remember, the defendant bears the burden of proof here, and it is a very, very heavy burden. It is a difficult defense to establish. In order to help you understand how the defense is applied and the high burden that rests with the defense in these types of cases, I've given you summaries of a few cases where the defense was advanced. So the first case is McIntosh and Bell. It's an Ontario Court of Appeal decision. In this particular case, the defendant lost control of his vehicle on icy roads and tried to raise the inevitable accident defense. This defense, though, did not fly in this case. It was unsuccessful. And the reason it was unsuccessful is that the court argued, or the court held, that a driver should always have control of their vehicle and should drive the vehicle to account for the road conditions. And so the manner in which the defendant drove his vehicle could have certainly been controlled. For example, he could have slowed down his vehicle. When the court in this case looked at the defense of inevitable accident, it indicated the following. It said, a person relying on this defense must show that something happened over which he had no control, and that the effect of which could not have been avoided by the greatest of care and skill. The court indicated that this means, or they said, this seems to me to be the very distinction which was taken and was meant to be taken between the case of inevitable accident and the mere want of reasonable care and skill. They indicated that a man can only get rid of the consequences of the circumstances which indicate negligence on his part by showing that the cause of the collision was a cause not produced by him, but a cause the result of which he could not avoid. Inevitable means unavoidable, and unavoidable means unavoidable by him. So it is a very, very high onus for a defendant to meet, and icy roads and losing control on these icy roads is certainly not a basis for the defense. You should always have control of your vehicle. And if you don't, liability will rest with you. It is not an inevitable accident. Now, another case that I included is Al Dali and Panjalingam. It's an Ontario Court of Appeal decision as well. This case also involved poor driving conditions, and the defendant again tried to raise the inevitable accident defense. The defendant was unsuccessful. But what the court did in this case is they talked about the burden of proof, and they indicated that the plaintiff has the burden to prove prima facie negligence on the part of the defendant. And once the plaintiff shows that the defendant is prima facie negligent, so for example, that the defendant's vehicle crossed the center line, or the defendant failed to stop at the stoplight, once the plaintiff shows that, the onus then lies on the defendant to demonstrate that the accident could not have been avoided by the exercise of reasonable care. And that, again, is a very, very difficult burden for the defense to meet. The third case I included is Boomer and Penn. This is an Ontario Superior Court of decision. It is a case where the defendant had a medical event and tried to argue inevitable accident. The defendant was diabetic. He suffered an insulin reaction while driving and caused the collision. Now, the defense here was unsuccessful, and this is quite frankly a case that I relied upon when I was dealing with that trucking case. The reason it was unsuccessful is that the court found that the defendant was aware of his medical disability and could have taken precautions to prevent the attack. For example, he could have had sugar on hand to remedy the attack. And in this case, the court discussed the very heavy burden of proof. And what the court said is that the test to be applied is whether the faculties of judgment of the driver became impaired to such a degree that a reasonable person could not regard his operation of the motor vehicle in the manner complained of as the conscious act of his will. The onus of establishing that the acts or omissions were not conscious acts or omissions of the driver rest upon the driver, and it is not discharged, that onus is not discharged if the court is left in doubt on that subject. The court further held that a motorist who suffers from a disability of which he is aware bears a heavy duty to take the necessary steps to avoid the possibility of his illness creating a situation that would make it impossible for him to discharge his duty of care. So, as you can see from the 3 cases I've included, is that the onus on the defendant in advancing this defense is incredibly high. And for this reason, the defense is very rarely successful. In the few cases where it has been successful, I've seen it successful in a case where a deer darts out in front of the vehicle and there was nothing the driver could do to avoid the collision. But in most cases, there is typically something the driver could do, such as driving slower for the road conditions, or if there's knowledge that there's deers in the area, the driver could have been more vigilant and cautious. But again, this is not to say that the defense is never successful. To give you an example, there's a British Columbia decision, Chow, CHOW hyphen Hidaso, HIDASO. And in this case, the defendant lost control of his vehicle while his wife, who was the plaintiff in this action, was in the front passenger seat. And the defendant lost control of the vehicle because of a mechanical malfunction. On the day before the accident, this is what came out in the evidence, the defendant had a safety inspection conducted on the vehicle in anticipation of his trip, and he checked the weather forecast and road conditions before he left for her trip. So the defendant raised this defense saying he did everything reasonably possible to ensure no malfunction of his vehicle by having it safetied and checking both the weather and the road conditions. And the court here held that a mechanical failure would only qualify for the defense of inevitable accident if it could not have been prevented by the exercise of reasonable care. And the court reasoned that even if a defendant experienced a sudden mechanical failure, the defendant would still need to prove that he exercised reasonable care in responding to the emergency before relieving himself of liability. In this particular case, the court held that the defendant could not have reasonably discovered the defect or prevented the collision. The court based this decision on the fact that the defendant regularly and prudently had the vehicle serviced and maintained, was alert and well rested on the day of the collision. He was not driving at an excessive rate of speed. He was completely unable to steer the wheel once the brakes malfunctioned, and he responded immediately to the malfunction. The court, in essence, held that the defendant tried his best to respond to the situation and that his choice of response was reasonable in the circumstances. For this reason, the defense of inevitable accident was successful in this case. And what the end result of that was that his wife, who was injured in the accident, was unable to recover any damages in tort from her husband. And this particular slide is the one that deals with the Chow and Hidaso decision that I just talked about. So let's move on to the next slide. The last topic that I want to deal with in this lecture is pedestrian cases. And the reason that I have included it here is because there are special considerations that apply when the plaintiff is a pedestrian. And those considerations apply by virtue of the fact that the plaintiff is either walking across the street or riding a bicycle, and they are then struck by a vehicle. In a typical motor vehicle accident claim, the plaintiff has the onus of proving liability, that in essence, the defendant is at fault for the collision. When, however, we are dealing with a pedestrian case, there are special considerations that shift that onus of proving liability onto the defendant. This is called a reverse onus. And with the reverse onus, the motorist or the operator of the vehicle is deemed liable and must then prove that he or she is not liable for the collision and the plaintiff's injuries. The reverse onus emanates from Section 193, subsection 1 of the Highway Traffic Act, which is on the next slide. Section 193, subsection 1 indicates that when loss or damage is sustained by any person by reason of a motor vehicle on a highway, the onus of proof that the loss or damage did not arise through the negligence or improper conduct of the owner, driver, lessee, or operator of the motor vehicle rests upon the owner, driver, lessee, or operator of the motor vehicle. So the way this works is that once the plaintiff establishes damages, so for example, that they suffered an injury because they were struck by the vehicle, the onus of proof then shifts to the defendant to establish that he or she is not at fault for the collision. The defendant, the person who operated or owned the vehicle, is presumed to be negligent in these cases where we are dealing with a pedestrian. Now, when the defendant attempts to establish that the defendant is not liable, it is not sufficient for the defendant to merely show some evidence of contributory negligence on the part of the pedestrian. So, for example, it's not enough for the defendant to say that the pedestrian didn't cross the road in the crosswalk. If at the conclusion of the trial, the evidence of negligence is equally balanced as between the plaintiff and the defendant is entitled to succeed because the defendant is presumed negligent. The defendant must establish on a balance of probabilities that he or she is not negligent for the collision and plaintiff's damages. So again, the defendant's onus here is not satisfied by simply showing contributory negligence on the part of the plaintiff. The defendant must prove that he or she was not at fault for the collision. This requirement was set out in the Shapiro and Wilkinson case, where the Supreme Court of Canada held that the defendant's obligation was to satisfy the jury that the loss or damage did not arise through any negligence or improper conduct on his part. If they are so satisfied, that is the end of the matter. If they are not, it would then be open to the jury to find that the plaintiff's negligence caused or contributed in part to the accident. So again, the issue here is the defendant completely exonerated? And if not, the defendant is liable, and the jury would, however, still look at apportionment of liability between the defendant and the plaintiff on account of contributory negligence. With pedestrian cases, another important consideration is the location in which the collision occurred. The onus of proof on the defense is even higher when the motorist was driving in areas where children are typically found. So if the owner or the driver of the vehicle is driving in a school zone or near a playground or where there's a known bus stop, for example, if children are typically found in that area, the driver will have an even higher onus of establishing that he or she is not at fault. The courts have recognized that the presence of children by or near a roadway is inherently dangerous, and that children are prone to, do unexpected things such as dart out into the roadway. And because of that, the court has held that drivers need to expect the unexpected, particularly when driving in areas where children are typically found. So a higher duty is placed on drivers in these circumstances. Think of cases where there's a pedestrian crossing sign in the area, or it's a school crossing zone, or there's schools in the area, or even residential houses in the area. The defendant has an obligation to be much more vigilant when driving in those areas. I had a case where my client at the time of the accident was a 10-year-old girl who was walking her bicycle across the street, and she wasn't in the crosswalk, and it happened on Wyandotte Street, and the defendant was coming home from work, and she was driving in the inside lane, the one closest to the center line, and at this portion of Wyandotte Street, the curb lane was designated for parked vehicles. Well, there were no parked vehicles at the time. There was a vehicle turning left in front of the defendant driver. And so, without thinking about it, what she basically did was passed the turning vehicle on the right, didn't see my client, and struck her. And the reverse onus was really the argument that I hammered here, saying that she had an obligation, to be more vigilant. The area where the collision occurred was near a local school. There was a crosswalk very close to that area. It was also a known bus stop. And there were 4 children standing on the other side of the road waiting for my client to cross. And so because of the presence of those children and those other factors that I mentioned, she had an obligation, the defendant in this case, to be much more vigilant, making her burden of proof much higher in this particular case. So, when you're looking at tort claims, mere compliance or non-compliance with the applicable regulations is obviously not determinative of any issues of liability. Liability in these tort claims will always turn on, considerations of road conditions, traffic conditions, signage that's in the area, visibility, activities that are engaged in by both the driver and the pedestrian. So it's not just about what the driver of the vehicle did or did not do. You also need to look at the totality of the evidence and what was happening around the driver at the time of the incident. So typically, when dealing with these types of cases, particularly with pedestrians or even with helmets and seatbelts, both parties will often obtain engineering evidence to look at the visibility and the reaction time and the force of the impact in order to prove their case. So this is the end of the first video. I hope you were all able to view the video without difficulties. If there were any difficulties, please do not hesitate to email me, and I will do my best to ensure that you all have access to the videos. Watch out, there will be 2 more videos posted, one being the lecture that would have taken place on March 24th, and the third being the lecture that would have taken place on March 31. So stay safe, everybody, and let me know if you have any questions or need any assistance. Otherwise, I will be in touch shortly on the details of the revised examination. Thank you.